right. So let's continue to talk on agency relationship. Now, let's look at the duties. It's important to know the duties of an agent, and you see that an agent has a lot of duties. And because they have a lot of duties, this is something you should keep in mind if you ever become an agent. A pure agent, I mean. If you're an employee and you also act as an agent, okay, you're being paid for that. But if you are a pure agent, you see that you have a lot of duties, meaning you should be paid as much as possible. So because it's a contract, we know it's a contractual relationship. The first obligation is to comply with the terms of the contract. Anyone who is in a contract, they have to comply with the terms of the contract. Now, as I said before, the agent may be liable for acting beyond authority. The agent may be sued for breach of contract. So the principal may sue the agent breaches the contract. Now, the agent owes a duty of reasonable care to the principal. So a duty of being reasonable care, remember, duty to be careful. Duty to be reasonable, careful comes from tort law. Remember negligence. So the agent has to be careful when they are dealing with third parties because they owe the duty to the principal. The agent must not go against specific instructions. So if ICBC tells their insurance agent not to do something, the agent must not go against those instructions. The agent cannot delegate responsibility unless the agent discloses this to the principal and the principal consents. I'm an insurance agent. I want to be 1 month in Hawaii for vacation, and I want to delegate this to another person. I can only do this if I tell ICBC, and if ICBC agrees, if ICBC consents. There's a fiduciary duty. So we've been talking about fiduciary duty already. You know that this is an enhanced duty, the duty of utmost good faith, the duty that makes the agent loyal. The agent must be loyal and can only act in the best interest of the principal. So there's fiduciary duty here in the agent and principal relationship. And the agent, they own a positive duty of full disclosure. What is this positive duty of full disclosure? Well, I'm an agent. I'm a selling agent. So I'm selling an apartment to someone. If I know the buyer, if I know the buyer has some credit issues, I have a positive duty. I have to take initiative and disclose this to my principal, the seller. Just if I know. If I don't know, there's nothing to disclose. So this positive duty, it means that the agent needs to take initiative to share whatever information that comes to their hands, whatever information they know. Agent cannot act for principal and third party at the same time. Well, my sister is my agent in Brazil. My sister cannot act for me and for the bank at the same time as an agent, unless both the bank and myself, but mainly myself as the principal, unless I know, my sister tells me that, and I consent. There are some situations that the law prohibits. In BC, the law prohibits a realtor to be an agent for both the seller and the buyer. This is prohibited by law. The seller needs to have their own selling agent. The buyer needs to have their own buying agent. Okay? What else? Agent cannot profit at principal's expense. Agent cannot compete with principal. I'm a selling agent for, let's say, I'm a selling agent for Apple. So I sell Apple products. I cannot sell Samsung products too. I cannot sell Google products too. I cannot compete. This brings a conflict of interest. Unless there's disclosure and the principal allows. This is what happens with brokers. Brokers, they represent several companies. like mortgage brokers. And then they offer the mortgage that has the better terms for the clients. And then there's also fiduciary duty in professions for professionals and their clients. So there's this enhanced duty between a lawyer and a client, between a doctor and a patient, an accountant and a client, a business consultant and their client, etc. Now, fiduciary duty is also owed to indigenous peoples, meaning the government, they have a fiduciary duty, this duty to act in loyalty in the best interest of indigenous peoples, specifically regarding to land. So this is not related to agency law, but it's related to the fiduciary duty. And it's important to know the fiduciary duty. Now, we've seen a lot of duties from the agents. So that's what I told you. That's why I told you, if you are an agent or if you become an agent, you should remember that you have a lot of duties on your own. And if you fail to meet, to comply, to live up to those duties, you may be sued. Now, the principal, what are their duties? Well, again, honor the terms of the contract. That's the main duty of the principal. The principal is vicariously liable, but their duty is mainly the ones in the contract. Now, in the agency contract, if there are ambiguities regarding authority, if the authority has ambiguity, the courts, they will interpret authority as broader as possible. Because courts believe that the agent is the weakest party in the agency relationship with the principal. Okay, so courts will favor the agent. Now, the agent's liabilities. So the agent can be sued by the third party. Remember, the agent can be sued by the principal if they breach the contract. If they fail, if they breach their duties, if they breach their fiduciary duty. But the agent can also be sued by the third party. Now, the banking institution in Brazil could sue my sister personally. In which situations? When the agent goes beyond their authority. So if the agents go beyond their authority, they can be sued for breach of contract by the principal, and they can also be sued by the third party. Why? Because they are breaching their warranty of authority. Warranty here means representation. When my sister goes to the bank and she gets a loan, so she's going beyond authority, she is breaching the warranty of her authority. She's telling the bank that yes, she can get a loan, but actually she cannot. So she is breaching her warranty. She is intentionally deceiving, eventually, the bank. So as an agent, you could be sued by all sides. You could be sued by the principal, breach of contract, breach of duties, fiduciary duties, and you could be sued by the third party when you go beyond authority. Now, the principal is vicariously liable. This we already know. So just emphasizing, they are vicariously liable when the agent acts wrongfully, but within authority. Within authority. If the agent acts beyond authority, then the principal is not vicariously liable. Okay, because it's beyond. Now, when does the agency relationship end? Well, it ends when the contract says so, or when the agent is notified by the principal, or when the project ends, when employment ends. There's an end in the relationship. Eventually, when the principal becomes, passes away or becomes insane or bankrupt, this also ends the agency relationship. Now, we talked about power of attorney. So I told you that a lawyer gets a power of attorney. My sister has a power of attorney. But now there's this other type of power of attorney that is called The enduring power of attorney. Well, I just told you that if the principal becomes insane, the agency relationship ends. This is not the case for enduring power of attorney. The enduring power of attorney exists to survive insanity, unconsciousness of the principal. So I would say this is not legal advice, but I would say in Canada, most people, if not everybody, should have a power of attorney. Why? Because the power of attorney is made when we are in good health, so that when we are in bad health, our agent can act on our behalf, on our interests, for health decisions, for financial decisions. So this is something that most of everyone in Canada should have, an enduring power of attorney. And you should have as your agent someone you trust, usually a family member, usually a very close friend. Because if you are not under conscience, let's say someone who suffers a stroke and are in coma, someone who's admitted urgently to ICU, and then who will make, when they are without conscience, they cannot make a power of attorney anymore. So the enduring power of attorney is made while we are healthy, so that when we are unhealthy, our agent, the one we trust, they can decide financially for us, health-wise for us. Okay, that's what an enduring power of attorney is. So that's agency. And I know I spent quite some time in agency with you, but it's important for some reasons. First, I've given you several examples of agency relationship, meaning that several situations in our lives, the law of agency applies. So that's why it's important. Second aspect, the law of agency is applicable to partnerships. So most of things that we discussed in the law of agency, I will not repeat here, just emphasize to you, just mention that this is because of the law of agency. So the more you know the law of agency, the better you can understand partnerships. Okay, so let's talk about business entities now. There are other types of business entities, such as nonprofit, holding, there's societies, but we'll be focusing here only on three: sole proprietorship, partnerships, and corporation. In this chapter 10, we'll go through sole proprietorship and partnership, and then chapter 11, we'll go through corporation. Now, when we talk about business organizations, we talk about ways people can do business in Canada. So you want to sell a product, you want to sell services. Which way will you sell them? Will you be a sole proprietor? Will you form a partnership? Will you set up a corporation? You can choose. And there are advantages and there are disadvantages in all types. So that's the idea here. Now, I teach another course, not here, in a different educational institution, that is only about company law. It's only about business organization. So we spend the whole term talking about, so there's one class talking about sole proprietorship and partnership, 2 classes on partnership, and 10 classes on corporation. Okay, I will not be that detailed here. I'll just give you a very glimpse, an overview of all of them. Okay, so we're going to start with sole proprietorship. Simple, very simple. It is the individual doing business alone. Key words here: individual, alone. I do business alone. What kind of business? Any business. I could be a business consultant. I could be a lawyer. It could be a gardener. It could be an electrician. It could be a lecturer. Any business. But I do alone. It's myself doing business. I, as an individual, I am the business. If I am the business as a person, can the business be sold? No, because I am the business. As a sole proprietorship, the business cannot be sold because I am the business. I am the person. I can sell the assets, If my business has cars, real estate, patent, those assets could be sold, but not the business, because I am the business. If I pass away, the business dies, because I am the business. Can I have investors? Can I have partners in my business? No, because I am doing business alone. So some advantages here is that I cannot sell the business as a sole proprietor. I cannot have investors. I can get loans. Loans I can get, but I cannot get investors. Right? So some advantages here.
Can you have employees?
Yes, I can. So I'm a sole proprietor, I'm a gardener, and sole proprietorship is usually under my own name. But if I want to have a business, commercial, trade name, then I need to register. But if I don't want to have a trade name, I will have my own name. And then, yes, I can have employees. I can have an office. I can have banking account, etc. But I am doing business alone. And I can have employees. And because I can have employees, I am vicariously liable for the mistakes of my employees. If I have an office, I need to adhere to licensing laws, zoning, bylaws. Can I start a restaurant as a sole proprietorship? Yes, it's myself. Any types of business, unless that specific business is prohibited by law to be a sole proprietorship. I'm not aware of any, but there may be, I don't know all laws. So it's straightforward. You are doing business on your own. No registration needed. Unless you want to have a trade name, a commercial name. You can have employees. Now, the main advantage is that your personal assets, they are at risk. Because the creditors, they can come after your personal assets for your financial obligations. In other words, because you are the business matters, financially speaking, they are not separate from your personal financial matters. So if I am a millionaire on a personal level, I should think twice to start a business as a sole proprietorship, because my millions at the savings account will be at risk. What if my employee makes a mistake and someone dies because of mistake of my employee? I may have to pay millions in compensation. If my business as a sole proprietorship cannot afford paying those millions, my personal savings will be at risk. So that's the main advantage of a sole proprietorship, which is the unlimited liability for financial obligations. How do we mitigate? How do we mitigate risks, financial risks? Insurance. I'm a sole proprietor, I'm a millionaire on a personal level, so my millions are at risk, but I can mitigate, not eliminate, but I can mitigate my risks, my business risks, by purchasing liability insurance. Then if I'm sued for up to 1 million or 2 million, depending on the coverage of my insurance, I will make a claim to the insurance. Right? Yes.
That could be done by the sole proprietorship, like itself, like the business himself, like if there's a person that owns like a business, like by himself, like in, like, WorkSafe BC, which is like if they get an injury themselves, can they also like do a claim?
No. WorkSafe BC is not available for sole proprietors. They are available for the employees of sole proprietors if the sole proprietors register for WorkBC. But WorkBC is only available for employees. And as a sole proprietor, I'm not an employee. Nor is WorkBC available for partners. And there's a very key case law on that. As a partner, my only remedy is to have insurance. So as a sole proprietor, I would get liability insurance. I could get life insurance. I could get disability insurance because WorkSafe BC wouldn't be available for me as the business owner. Okay, good question. Okay, are we good? That's sole proprietorship. I won't complicate anymore because it's straightforward, it's simple. Person doing business on my own. Let's say you hire me to be your tutor for a law course. I just raise an invoice, $50 per hour. I raise 1 hour to you under my name. I'm a sole proprietor, no registration required, everything. Okay, straightforward. Now, if I want to have partners, I will form a partnership. So a partnership requires 2 or more people, because if it's only 1, it's going to be a sole proprietorship. But if it's 2 or more, could be 50 partners, could be 100, could be 1,000, no limits. Yes.
Person want to set up a big business, do they have to take permission from the law for that in sole proprietorship?
Yeah, here, I'm not talking about the specific types of business. If you are a manufacturing, or if you are a reseller, wholesale, retailer, etc. So yes, you do need to comply with registration and licensing for the specific business matter you want to deal with, regardless of what type of entity you are. Okay, so what we are discussing is entities or business organizations. Now, the specific requirements for each business type, this is something different that you need to check with municipality, with federal government, eventually provincial government, because each business has their different requirements. Okay, so partnership, 2 or more people, and they are own business with the objective of making a profit. This is important. If 2 or more people are in business with the objective of making a profit, regardless if they make a profit or not, because it may be that the partners, they are bad business people, or it may be that the business opportunity is not good. But if their intention initially was to make a profit, they are in a partnership. And why I'm telling you this? Because partnerships can be created inadvertently. What is this? You create a partnership without intention. You create a partnership based on your acts. The 3 of you join money, you buy baking ingredients for muffins, you bake the muffins, and you go to Stanley Park to sell them. Did you intend to make a partnership? No, in principle not. You were just together making some extra money on the weekend, but you created a partnership inadvertently. And because you created a partnership inadvertently, partnership law applies to your weekend venture. And now let's say I bought your muffin. You are the 2 poor partners. You are a rich partner. So I will sue you for my sickness, for my medical doctors. I'll sue all of you, but I will most likely collect from you because you don't have money. You are a poor partner. You are a rich partner. Why? Because you created a partnership inadvertently. In other words, you did not see it. You did not discuss about a partnership contract. You just decided to join money, join resources, make the muffin together, bake, and go for sale. Make sense?
Have partnership. No profits.
Okay. We're not talking about non-profits. Non-profits, as I mentioned before, yes, they are other types of societies, but we're talking about business organizations. So now, you are in a partnership. It could be that you didn't sell all your muffins. You only sold half of them. And let's say you didn't make profits. But your intention was to make profits. You didn't make profits because you were not able to sell all of them. You are still in a partnership. Because it's not about making profit. It's about the intention. Do you intend to make profit? If you do so, you are in a partnership. So we should avoid creating partnerships inadvertently. We should seat, we should discuss, we should come into an agreement. Partnership is by agreement. That's why we study contract law in this course, because you have a partnership contract, you have an agency contract. In other words, contract law applies to partnerships. Now, there's a partnership act. This is a provincial act. BC has one, Alberta has one, Ontario has one. So if you are forming a partnership in BC, you need to be knowledgeable about the Partnership Act of BC. If you're forming a partnership act in another province, you should be knowledgeable about that act or seek legal advice there. So the presumption of partnership is what I mentioned, your example. It's presumed that you created a partnership inadvertently because there was joint contribution of capital, you intended to share expenses and profits, and you participated in the management of your weekend venture. You decided who would sell, who would pay, etc. So I just told you it's created by contract. Now, can contracts be verbal? Can contracts be verbal or not? Yes. Should we use verbal contracts from a legal risk perspective? No, we should avoid. So it's better to be in a partnership through a written contract, so that the terms are expressed, parties are clear on what to expect. Now, some rights and obligations from the Act, they may be modified by agreement. Some, not all. For example, where is it? Here. The Act says that profits and losses are shared equally. Equally. So in your partnership, 33, 33, 33, equally. But let's say you are the richest partner, you are investing more money. So you can agree that you keep 50% and you share 25, 25, for example, if you want. But if you don't make an agreement, the Act applies. And the Act says that it's equally shared. Okay, so that's important. The rights and obligations from the law, some of them can be modified by agreement, as I just exemplified. And now, those rights and obligations, they do not affect outsiders. Why are outsiders not affected by the partnership agreement? Because the partnership agreement only affects the partners. That's privity of contract that we discussed in agency law. A contract does not affect outsiders and does not affect others. So you see how we build on the concepts. We get the concepts from contract law and we apply law. In agency law, we apply partnership law. Now, creation by Stoppel is the inadvertent partnership. Now, because you were aiming at profit selling muffins on the weekend, you have created a partnership. So you cannot deny the transaction. All of you are liable. Now, registration is required, and I say here usually. Usually, because I don't know the partnership acts of all provinces in Canada. But I know a little bit about the Partnership Act of BC. And in BC, a partnership has to be registered. So you have to register a partnership. Remember, you don't register a sole proprietorship, but you register a partnership. It's a simple form you register with the provincial government. Okay, you pay a $40, $50 fee. Now, rights and duties. Well, as I mentioned before, the rights and duties of partners can be negotiated, can be modified by the partnership agreement. If they are not, the law applies. Now, there are some types of rights that cannot be modified. The main one is major changes. When there's a major change in the partnership, unanimous agreement is required. So in this partnership here, you have 25, 25, and 50. So this partner is the majority partner. But if it's a major change, now you sell baking products, you want to change to services. Even though you have only 25, unanimous agreement is required. So this is one of the advantages of a partnership. Because if you are in a company, if you are a minority shareholder, you don't have a say. The majority shareholder, they do whatever they want, but not in a partnership. Partnership, regardless of how much interest you have, major changes, you have to accept. Okay. Now, fiduciary duty. We just discussed about fiduciary duty. So here I'm just mentioning to you that partners, they owe a fiduciary duty to the other partners and to the partnership too. And everything I'm talking is about a general partnership, because there are two other types of partnership we'll discuss in a minute. So this is a general partnership. Now, fiduciary duty. The partner has to act in the best interest of the partnership. So you have a partnership selling muffins. You cannot make cookies and sell on your own, because cookies related to muffins, and you would be breaching your fiduciary duty. Unless you talk to your partners and say, hey, I also want to sell cookies. I don't want you involved. Are you okay if I do cookies on my own? If they say no, we're not okay. You have to do cookies in the partnership. Then you have to. Now, I told you that the laws of agency apply to partnerships because partners, they are agents of one another. What does it mean? It means that everything a partner does binds the other partners, binds the partnership. The baking partnership here, it was not a written contract. It was an advertent, actually. Let's say unknown to both of you partners, the third partner got a loan. Whatever the partner does binds you. So you are also bound by the loan. I didn't sign the loan. Because you formed a partnership, your signature is not required. You are a partner of each, you are an agent of one another. What I'm saying is, it's risky to be in a partnership. But it doesn't mean you shouldn't form a partnership. It just means that you should seek specific legal advice. You should set a detailed partnership contract so that you can negotiate the terms.
Is that the operating agreement?
Could be an operating agreement, but it has a function of operating agreement, but it's more than operating agreement, because it's the agreement for the partnership as a whole, the powers, the rights, and the obligations.
Isn't this the operating agreement? Yeah.
Operating agreement could be more related to the operation of a business, could be more specific. So there's operating provisions in the partnership agreement, but there's also other provisions, such as responsibilities, liabilities, interest, location, name, prohibitions, etc. So it's more than an operating. Okay. Now, vicarious liability is also applicable here. All partners are liable for the conduct of the other partners. Regardless who made a mistake, all partners are liable. The partner got a loan. I am the bank who gave the loan. I can sue all of you. Oh, but only the partner got the loan. You are partners of one another. You are agents of one another. You are fully liable for all the deals. You have 50%, you have 25, you have 25. The loan is $10,000. If I sue all of you, how much will you pay to me? I gave a loan to you of $10,000. You have 50%, you have 25, you have 25. I'm suing the three of you for $10,000. How much can I recover from you specifically, or from you, or from you?
50% of 10% and 25%. So like it'll be like kind of like.
No.
Oh,
No, surprisingly, no. Because you are partners of one another. Third party can collect from any partner the full amount. But there's an explanation. The 50, 25, 25. Is this an agreement among the three of you or not? Does this agreement bind me, an outsider? No. So I collect the full amount from you because you are the richest partner. You pay me $10,000 back.
Of money, because the contract is between them.
Exactly. The partner will pay the full amount to me eventually because they are the richest one. Now, because the agreement is between the three of them, now you sue them for their part. So the 25 and 25 will be among them, not with me. Does it make sense? The agreement only binds the parties to it. So your agreement 50, 25, 25 does not bind me as a bank. I can collect from any of you.
But they find the company, not the partner.
I sue both the partnership and the partners. Why? Because partnership is also an individual. It's based on the individual. It's not a separate legal entity. The same as, and this is an important thing I didn't clarify or I didn't make it explicit. Partners, they are people. So the business in a partnership is also a people business. The same as a sole proprietorship. Now, one difference is that your interest can be sold to another partner if the other partners agree. You can sell your interest. Yeah, but you cannot sell yourself. Now, let's think about this example here. There's a partnership in which partner A contributes with 2% and partner B contributes with 98%. So partner B is rich, partner A is poor. That's why partner B contributes more. But why? Because let's say partner A is the scientist, is the inventor of something. Now there's a loan of 10,000, 10K. Let's say partner B is richer when they invested, but let's say they have no personal assets. And partner A has personal assets. Let's say they have an inheritance or whatever it is. Can this 10,000 be recovered fully from partner A? Yes or no? The answer is yes. That's what I'm saying. A third party can collect from any partner. So as a bank, as a financial institution, as a creditor, I can collect from any of them. And then you may think, well, it's unfair. It's unfair that partner A has only 2% interest in the partnership and they have to pay the full amount. Well, when they formed the partnership, they knew the rules, or they should have known the rules of partnership law. And now it's unfair. It may be unfair, but then A, after they pay the 10,000, they can sue B under their partnership agreement to collect the 98%.
Can we putting in agreement any clause against that?
No. No, because anything in the agreement will only bind A and B. Will not bind this. You cannot agree on something with an outside if the outside is not part of the agreement. And that's something that people usually think of, yes.
So if the bank goes to A, collects the $10,000 from A, then A can sue B for the remaining 98%. The company
Yes.
can absorb that amount, so he becomes the sole owner. Or he just sues him for the $10,000.
Oh, no, sues for the $10,000.
Okay, so wouldn't,
But while suing for the $10,000, yes, the 98% is one asset. So they could use this as a form of payment, but they are suing for the amount, for the money.
so he could give part of like the percentage to A.
If they settle, if they agree, it's fine. They are free to agree as they wish.
But if the banks go after like a group of 3 partners and they go after one partner in specific and you charge him like $10,000 or whatever, wouldn't it make sense that since they're all in partnership together, the other 2 have to kind of like pay back their fair share to A, who got all of it?
That's what it is. That's what it is. What I'm saying here, regardless of how many partners there are here, a creditor can sue all of them. But if it happens that only one can pay the creditor, they will be paid by only that one. But then the one will have remedies under contract against the others. Okay? Well, rest assured there will be a question like this in your midterm exam next Tuesday. You should remember that a third party can collect from you. Now, some advantages for a partnership. It's the less costly form to operate. Yes, you form a partnership through a contract and you have a $40, $50 registration form. So it's not costly. So how do you dissolve the partnership? When one partner wants to be out, if there's only 2 partners and one wants to be out, then the other cannot be in a partnership because 2 are required. If there's a date, and eventually if the partnership is running into loss after loss, the partners can request to court and court will dissolve the partnership. Okay, distribution of assets and liabilities, we already know. So this is all about a general partnership. Now, there's one type of partnership or partner actually that is called the limited partner. A limited partner will have their liability limited. But there's no free lunch, as we know. If my liability is limited, my rights are also limited. So it can only be a limited partner if I don't take control of the business, if I don't manage the business. And also I need to be registered. I need to be registered with the province as a limited partner. So in this example here, again, A and B, A, B, 2%, 90, 80%. A would be better off being a limited partner. If they are a limited partner, all they can lose is the 2%. So if I am a creditor, I can collect 2% from A, but then everything else will be collected from B. So you can limit your liability, but you don't participate in the business. If you don't participate in the business, you are primarily an investor. You are an investor. You are advancing money to help the venture, but you don't have a say in the business. What if you register and then you fail to be out of management? You lose your status as a limited partner. You will lose your status. Okay, so that's a limited partnership. And there's another one that is the LLP, limited liability partnerships. Well, the LLP needs to have an LLP in their name. Can you Google there, KPMG, Canada? Does it say KPMG LLP? Does it say? Anyone? KPMG, Canada? Does it say KPMG LLP in their name? No?
No.
KPMG International.
Yes. Yeah, it's.
Yeah, maybe, yeah.
KPMG, Canada. Here. KPMG LLP. So we know KPMG is a limited liability partnership. How do we know? Because whenever you are an LLP, you are required to have LLP in your name. If I just make law firm Vancouver, most of law, not most, but there are a lot of law firms that are LLP, 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 LLP. Do they have to be an LLP? No, they don't. But if they are, they need to have LLP in their names. Right? Now, what is the beauty of an LLP? The LLP is a kind of a mixture of a general partnership and a limited partnership. In an LLP, a partner is only fully liable for their own mistakes and the mistakes of their own employees. They are not liable for the mistakes, omissions, errors of the other partners, as we saw here in my general example. So if there are 50 lawyers, 10 lawyers, 100 lawyers in a law firm, and that law firm is an LLP, each lawyer is fully liable. Their personal assets are at risk, but only for their own mistakes, not for the mistakes of other lawyers. The partners at KPMG, the same thing. They are liable for their own mistakes, not the mistakes of others. In BC, any types of business, any people can form an LLP, but generally, it's a common practice that professionals, they form LLP. That's why we have accountants or business consultants as KPMG. That's why we have law firms. Could be doctor's office, could be dentists, etc. Does it make sense? So we saw the general partnership, we saw the limited partner. A limited partner needs to be registered and cannot manage the business. And a limited partner is only possible if there's at least one general partner that will be unlimited liable. And we saw now the limited liability partnership, in which partners are fully liable, but only for their own mistakes or the mistakes of their own employees. Like, I'm a lawyer in an LLP, in a law firm, and I have my own secretary, my own legal assistant, my own paralegal. I am fully liable for all our mistakes, but not of my partner's mistakes. That's the LLP. Now, what is a joint venture? Joint venture is this name. It's just a name. It's not a business entity. It's just a name for a project together. So when two people cooperate in a project together, and those two people could be two corporations, could be two partnerships, could be two sole proprietorships, and a joint venture could be a new business entity, such as a new partnership, a new corporation, or the most common way is through contract, a joint venture contract. Why? Why would people enter into a joint venture corporation? Well, it's because they don't want to mix their current business. Apple, they want to go into a driverless car project, but they don't want to mix their current iPhone, iPad, all their eyes business units. No, they don't want to mix that. They want to create a new, eventually a new entity, or they want to enter into a contract with, let's say, with Google, with Tesla, or with Build Your Own Dream, BYD, for that specific project, the driverless car. So a joint venture is a way to protect your current business units, to limit your liability, to limit the resources for that specific project. That's a joint venture. It's very common in big public projects. So there's a new bridge being built to replace the Patula Bridge. That's a huge construction. So eventually, there's more than one company together in that project. That could be an example of a joint venture. I'm not saying it is, I don't know, but that could be an example of a joint venture. Okay? Eventually, there's this fast train from Vancouver to Seattle or Portland. Also a huge project. Many companies could form a joint venture for that specific project. So that's what a joint venture is. And it's usually through contract. So here you have a summary of what we discussed with regards to sole proprietorship, general partnerships, limited partnership, and limited liability partnership. One question for you to practice before we break. Which one do you think is right and why? Which one? D? C. C. Partnership states clearly that a partnership is only, well, here's just an asterisk. In multiple choice questions, when we have only, never, always, we should be cautious because they usually trick us. Only created by specific agreement. Remember when they baked muffins and went to sell? There was no agreement there, and there was a partnership. So C is not right because it's not only created by specific agreement, could be created inadvertently. What else? E. B, Bob. A. B, Canadian partnership. No, remember I told you it's provincial partnership, no federal partnership. Remember I told you there's a partnership of BC, of Ontario, well, not this one. A, partnership always overrides provisions contrary to it, always. So the act says that profits are shared equally. What if they agree 50, 25, 25? It's the opposite. The agreement overrides the act. Not the act overrides the agreement. It's the opposite. D, partnership sets out provisions that will govern unless partners agreed otherwise. Statutory law, act, rights and obligations of the partners can be modified by agreement. Not the liability to outsiders. Remember that Lisa wanted to modify the liability to outsiders. That cannot be. But most of the rights and obligations, yes, can be modified by agreement. So yes, D is the right answer. And also there's no federal partnership. D is the right answer. Are we good? All right, so we went through the law of agency and we went through two of the three main business entities, sole proprietorship and partnerships. Okay, let's break and let's do corporations when we are back.